So I want you to meet Brad and Ronnie Olson. Brad is an attorney. He's operating in Pennsylvania and Ohio. So I want you to see what clients that I deal with face on a regular basis when they have attorneys on their side, quote unquote. This is a pandemic. When attorneys are required to uphold ADA rights, they're chicken shit. And they run and they gaslight the clients and they abandon the clients. This is what you're going to see in this case. And Ronnie Olson and Brad Olson exacerbated this client's disabilities, discriminated against this client on the basis of disability, and abandoned this client, coerced, intimidated, threatened, and followed through on the threat of abandoning this client on the basis of disability. And we've got it on record, and I want to show it to you. This happens every day. This is a pandemic, and it needs to be addressed, and we're going to start addressing it. So let's bring it out and show you what happens with clients all the time. So what I'm going to do is take you through and show you a quick chain of events here. March 13th, 2023, I sent in a request to the ADA coordinator for Columbiana County, Ohio, asking for ADA rights for my client. And I'm on this case with another ADA advocate as well. Sent this in, and they came back to me. I'm going to scroll down here. So then I gave them my email address. I told them that they had any questions, they could reach out to me. So that was on March 13th, okay? They came back, and they rescheduled this upcoming hearing several times. So here's a letter from the attorney, Brad Olson. But he says, enclosed, find the judgment entry which reschedules the replevin hearing for May 17th. And you're going to see something really interesting here. This is Brad Olson. It's got his signature on it. So, I mean, he's got notice of what this order or this judgment has on it. The replevin hearing is scheduled for April 17th and is continued for good cause based on the request for ADA accommodation in this case. So Brad has notice that there are ADA requirements that need to be addressed in this case, okay? And it was documented that the ADA has been invoked and that there were requests for accommodation in this case. They even said ADA accommodation right here, okay? So this was on April 13th, and it was scheduled for the 17th. So they had continued it several times. And then I wrote Mr. Olson, I wrote Brad and said, look, I will say that Rule 2.9 of the Judicial Code of Conduct is errant because it says that you can have ex parte. I'm going to paraphrase this. It says you can have ex parte, but it gives the opposing party a chance to oppose, which under the ADA is not allowed. As they have no business knowing what your ADA requirements are, nor opposing to them. Period. You're under ADA Title II, you're entitled to privacy and independence. So the other side shouldn't be involved at all in your administrative access to this. And so I wrote him and let him know, the privacy and independence. I gave him 28 CFR 35.160B2, which requires that. And I also tell him, the other side is not going to oppose if a deaf person wants hearing aids or a sign language interpreter or a paraplegic person using a wheelchair. I mean, imagine the opposing counsel saying, Your Honor, I oppose to them using a wheelchair in here because it prejudices my client somehow. Well, that's the same thing with somebody with invisible disabilities. They have the right to be able to access the court. And so the other side should have no say in that. ADA is administrative. I sign off on it, and I think this pisses them off. Okay. And then the client wrote Brad and said, I got your letter in the mail. Can you please ask for an ex parte hearing with the judge concerning ADA matters and ask for both my ADA advocates, Francesca Amato and Jay Shore, to be there, please. Thank you. And they sign off on it. This probably pissed him off even more because now he's got to have somebody involved that he don't want to have to deal with, which is me and Francesca. And the Columbiana County ADA coordinator comes back. Let me see who this is, if anybody signs this. Yeah, it's Jamie Schulis. Comes back and says, this is in response to your ADA accommodation request made on behalf of yourself and the plaintiff in the above referenced matter. Please be advised that as the court's ADA coordinator, I cannot administratively grant as an ADA accommodation A request that involves the judicial balancing of the rights of the parties or the judge's inherent power to manage the courtroom and proceeding. I will address each of your requests separately as follows. Basically, Jamie Schulis blows me off on all these ADA requests and says I've got to address the judge with it, which I cannot do as an administrative person. That's her job to do. However, should an in-person appearance be required, it should be noted that the courthouse is handicap accessible. We don't use the word handicap anymore. Accessible and ADA compliant. It is not ADA compliant if people with invisible disabilities cannot access the court, period. Signs off on it. I write back and say, Dear Ms. Schulis, this communication in response to your communication on May 5th, 2023, you're given notice of the following. I give her a link to a U.S. Department of Justice brief in a case. Judges do not enjoy absolute immunity for acts that are administrative rather than judicial in nature, which the ADA is. ADA is all administrative. Your term, the judge's inherent power to manage the courtroom and the proceeding includes the duty to administratively make their courtroom accessible under ADA law. And I go back and I address each one of these. I'm not going to go through these with you because they're deep and intensive, and plus they probably involve privacy rights. So between me and the client. So I sign off on it. I come back, and this is from the client to Brad. Dear Brad, I give my ADA advocates to be a part of all correspondence. Now, this is a nightmare for an attorney. I just got to tell you this. Because there's this thing called attorney-client privilege, and the control of that attorney-client privilege, this is not legal advice, but the control of that attorney-client privilege is in the hands of the client. The client determines whether that is waived or not. So she's going to waive it. Everything was sent through email multiple times with no response because he's not responding to this. Neither of them are appearing as attorneys, and they have separate, distinct roles as ADA experts and advocates. They both made that clear. The roles that they have the right to cite federal authorities and act in any manner to prevent ADA violations from occurring so I can be protected. Both my advocates are kind of professional. I'm sure this was a misunderstanding. Okay, so we keep going on here. And this is a case that I found recently. She's quoting this, Sugg versus City of Sunrise. So Sugg can actually demonstrate on their own. Actually, what happened here was Ronnie, and I'm going to play this recording for you, but Ronnie calls her and says, we need to get your medical records.
Hey, it's Ronnie at Attorney Brad Olson's office giving you a call to let you know Brad had that telephone conference yesterday. Judge made him aware of something the ADA advocates filed. We need to get that from whoever. Brad needs all that, and you need to get all of your medical records, all of them, as soon as you can. I will try calling you back again here shortly before I leave. Bye-bye.
Client says, hi, Brad. Shelby was supposed to call me back today and never heard from her. I'm not happy about this whole situation. I need my accommodations for my ADA access, which includes all my ADA advocates present by Zoom, please. The judge is way out of line for asking for and doing what they have because they've asked for these medical records. And so what do? They say, come in Monday, May 22nd at 3 o'clock. This is on May 16th. So I write back, and I'm writing Ronnie, and I say, Ms. Olson, Ms. Blank has clearly and unambiguously asked you for disability accommodations under Title III of the Americans with Disabilities Act. Title III applies to law offices. By ignoring her request, you and Mr. Olson are interfering with her exercise and enjoyment of rights when it comes to equal access to goods, services, facilities, privileges, advantages, or accommodations of the law offices of Bradley G. Olson, Jr. We aren't here for anything other than to assure that Ms. Blank is getting equal access under the ADA. That shouldn't be a problem, but it appears that it is. Okay, they write back and say, Dear Mr. Shore, this is Brad writing me. Dear Mr. Shore, do not communicate with my staff or make unfounded accusations against them or my office. No one is denied or other interfered with blank's rights. In fact, no court proceeding has actually been held in this matter, which blank was required to attend or participate. Simply because you disagree with the directive of the court that blank produce her medical records under seal to confirm the existence of a disability, that is against the ADA. That entitles her to special accommodations, gives you no right to make absurd accusations against my office or staff. The absurdity of me suggesting that them not giving her equal access under the ADA is actually a violation of the ADA. I mean, I understand. I know that's absurd. This is an attorney who doesn't know that his client has rights to not have to display their medical records to receive ADA access. This guy's a dumbass. Moreover, I have no duty or obligation to communicate with you directly. I have a duty to my client. Will communicate with her regarding her case and directives of the court. If she elects to utilize your services, that is her right. Okay, he's saying if she wants to use her services, that is her right. However, your drafting of documents to be filed with the court without my knowledge or consent as her attorney of record is unacceptable and may very well be the unauthorized practice of law as, based upon the credentials you identify in your email, confirms that you are not an attorney. I haven't asked the client to file anything with the court. The ADA coordinator is the administrative arm of the court, and this is outside of the courtroom. And this is the way that business is done with the ADA. Matter of fact, it's what they prescribe in the ADA, 28 CFR 35.107A. If I determine that your assistance is necessary during my preparation of her case, I will let you know. In the meantime, cease all future communications with my staff. If there's something I think you should explore, send it to me directly, and I will take the steps I deem appropriate and necessary. Very respectfully, Bradley G. Olson, Jr. Bullshit. That was a blow-off. And an accusation that I'm involved in UPL. So I write him back, and I say, Mr. Olson, quote, blah, blah, blah. This appears to be an unfounded accusation, as you so eloquently put it. Do you have the courage to act on your hubris, or is this just words? Every time they pull out UPL, I always ask them to go charge me with it. They never do. Because I want standing to challenge it under the ADA. And they never do. Just as you say I have no duty or obligation to communicate with you directly, I have no duty to obtain your permission to act in my federally protected capacity for my client's rights. If you have a problem with me, then you surely have a problem. Deal with it as you see fit, either with mere words, as you have already displayed, or actions. My prior email was to remove the plausible deniability. Thank you for responding. They write her back and say, you've got an upcoming appointment. You got to come into the office. I mean, they're going to intimidate her. That's what they're doing now with this. Thank you. I'll be at this. I'll be there with my ADA advocates on speakerphone, and they will be recording. I do not consent to attorney-client meetings being recorded. I waive attorney-client privilege. My client says, I waive attorney-client privilege concerning my ADA advocates. Ronnie, are you a licensed attorney? Because Ronnie is the one claiming attorney-client privilege here. Ronnie is a legal assistant. So she's involved in UPL now because she's writing and saying she does not consent to attorney-client privilege when she's only a legal assistant. She's not a lawyer. That's just my opinion. I'm not. The message was from Attorney Olson, and he does not consent to any recording. Mr. Olson has had, a client writes back and says, Mr. Olson has conspicuous notice that during the in-office meeting, I will have my ADA advocates on speakerphone, and they will be recording for disability mitigation and equal access. Thank you. And they write back and say, to be clear, Pennsylvania is a two-party consent state. Accordingly, if I do not give my consent to be recorded and you do so anyway, that's a crime under the Wiretap Act, regardless of the conspicuous notice you claim I have received. Well, he wouldn't be responding if he had not received a conspicuous notice, period. And he wouldn't even mention the conspicuous notice if he hadn't received it. You have become adversarial towards me simply because I relay to you the request of the judge to review your medical records under seal to confirm the disability and the accommodations that are necessary. That is against the fucking law. I was hired to litigate a conversion action, which I was quite willing to do. You have now, through your ADA advocates, accused me of somehow violating your rights based upon the judge's directive. At least this guy gets that we're accusing him of violating our client's rights. And yes, we are. Given your current position, obvious attempt to make unfounded accusations against me, I'm no longer willing to provide representation to you. In your conversion action, I will provide you with a billing statement and identifying the billable hours for my work and the expenses I paid from your retainer and issue a refund of the remaining balance. So then he writes a letter on May 18th. All this happened quickly. And so really he's admitting that this is about the judge asking for medical records for ADA. He's admitting that this is ADA related, and he's discriminating against her now and interfering with her right to receive equal access. And he's coercing and intimidating and threatening to drop her, and has followed through on that threat. So the coercion intimidation piece, total fees. So he charged her $5,000 she paid in a retainer. He's charging her $4,420 and giving her a $500 ADA refund. When he abandoned her ADA rights, coerced, intimidated, threatened, and interfered with her ADA rights. And I just wanted you to see this is how. What he tells the court, though, is this. Institution of the action on behalf of the attorney-client relationship between the plaintiff and the undersigned has deteriorated to the point the undersigned is unable to continue his representation of her interests. He's abandoning her on the basis of disability, because this was about him and his wife asking for medical records, and us balking at it because it's not allowed under the ADA. So here's a client who has endured extreme trauma, goes to an attorney, asks for help, and instead of helping and upholding her rights, the attorney abuses the client further. That's what's going on. And this happens on a regular basis. This is the first time I've been able to put it out with the permission of the client. Oftentimes the people I work with, are so many privacy concerns that I just have to keep my mouth shut. I mean, I see so much shit. This is one of the examples, though. And this attorney, Brad Olson, is the poster child now for abusive attorneys who do not want to stand up to ADA rights because they're chicken shit and they can't stand up to the judge. And instead, they want to take it out on the client, tell the client, pay the bill, I'm out of here. That's what's going on.